Good afternoon. Welcome to Holland & Hart's Compliance Webinar Series. Our next chapter is going to address fraud and abuse issues. My name is Kim Stanger. I'm one of the co-chairs of the Health Law Group here at Holland & Hart, and it's my pleasure to talk to you about some of the fraud and abuse laws that and the issues that come up in provider practices or at facilities. This is the next in our series of compliance webinars. We've addressed several topics already. We've got additional topics coming up next month. If you would like to participate in those and you're not currently on our email distribution list, by all means, just shoot me an email and we'll make sure that you get added so that you can participate in those programs. Next week, we'll be talking about the information blocking rule, but today we're going to be talking about key fraud and abuse statutes. Now, in addition, then we're going to be talking about how you apply those to some of the common situations that arise for healthcare providers. We'll talk about report and repayment obligations if issues have arisen that you need to correct. And then we're going to finish up with a few comments concerning the Provider Relief Fund. Now, a word of caution. We've got a lot of stuff to cover today. I may go a few minutes over. If so, I apologize. But we're going to be focusing primarily on federal laws and regulations. We've got a lot of people from around the nation on our call today. Just remember that we can't go into all those individual state laws, but you need to make sure that you are aware that your state laws may have applicable limitations in addition to the federal laws that we're going to talk about today. In addition, the application of the law may depend upon the circumstances of your particular situation, particularly which payer is involved. Most of the laws that we're going to talk about today apply if you are billing Medicare or Medicaid. If it's not a Medicare or Medicaid issue, then maybe the laws don't apply, but you may have different state laws that could apply. When it comes time to actually applying these live laws, then of course you've got to make sure that you check your applicable laws in your jurisdiction or under the applicable regulations to make sure that they comply with your particular situation. We provided written materials for you today, including some articles we drafted and red line versions of the new Stark and anti-kickback statutes. If you have not received those and would like to receive those, just shoot Laura an email and she'll make sure that she gets those to you. With that said, let's launch into our discussion about key fraud and abuse laws on a federal level. The government's active in enforcing fraud and abuse issues. I saw this that just came out on January 14th last week, that the government recovered $2.2 billion under the False Claims Act just in 2020 alone. Of course, that's just a drop in the bucket of all the money they've paid, especially all the money that they've sent out in the PRF funds. But nevertheless, if you're one of those people who had to repay part of that $2.2 billion, then it's significant. The government's main weapon in recouping fraud and abuse payments is the False Claims Act. The Federal False Claims Act says that you cannot knowingly submit a false claim for payment to the federal government, not surprisingly enough. Now, most of you are probably not going to knowingly submit a false claim, but the False Claims Act can arise in different situations. It could be a situation where you submit a claim for services that were really not provided as they were claimed. Maybe you mistakenly miscoded or upcoded, or you didn't provide the services consistent with the regulations, or you provided substandard care. There's a theory out there that when you submit that claim to the government only pays for medically necessary services or services that were provided with the appropriate standard of care. And if you provided substandard care or services that were not medically necessary, then you submitted a false claim to the federal government. In addition, in the wake of the Affordable Care Act, which I guess was enacted a long time ago now, if you did submit a claim to the government, a false claim to the government, and you learn about that or discover it, then you have an affirmative obligation to report and repay that overpayment that you received within the later of 60 days after you discover that or the date the cost report is due. We'll talk more about that a little bit later. So what are the penalties if you violate the False Claims Act? Well, at the very least, you will owe a repayment plus interest. You can also get hit up with civil monetary penalties of at least $11,000 to about approximately $22,000 per claim. Now, that's adjusted on an annual basis. I checked and I didn't see the annual adjustment for 2021, but those are the 2020 numbers. Now, note that that's a penalty per claim. So if you've got a pattern, you've been entering in the wrong codes for a long time, or you submitted a whole bunch of claims because when a provider wasn't properly licensed, for example, well, then each claim that you submitted could subject you to these penalties. You can also get hit up with an administrative penalty of $20,000 if you fail to timely report and repay an overpayment. You can also get hit up with trouble damages, and you can be excluded from Medicare and Medicaid. In addition, under the False Claims Act, you can be subject to a key tam action. A key tam action is a situation where the government has authorized private individuals to go out and sue you on behalf of the government. So they become kind of like bounty hunters. It could be a competitor, it could be a disgruntled employee. They sue you, and then if there's a settlement or a recovery, then those key tam relators get a portion of that recovery. So that's the False Claims Act. That's the main statute that you have to deal with when it comes to fraud and abuse issues. But there's some others we need to consider. The next is the federal anti-kickback statute. The anti-kickback statute says that you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by government programs unless you've structured that transaction to fit within a regulatory safe harbor. The government doesn't want you offering kickbacks in order to generate referrals. Now, a couple of comments on this. First, note that it is an intent-based statute. You cannot knowingly and willfully offer, pay, solicit, or so forth. That means that if you don't have improper intent, then there's no violation. The problem with that, though, is the government has concluded that the statute is violated if one purpose of the improper payment was to generate referrals or reward referrals. If one purpose of the statute was to generate that, even if you didn't intend to violate the statute, then it can be a violation of the statute and you can be subject to those penalties. So that one purpose test is a little bit hard to defend against. But next, note that it only applies to referrals for items or services that are covered by government healthcare programs, such as Medicare or Medicaid. So if you wanted to pay kickbacks for a purely private paid business, well, it probably wouldn't violate the anti-kickback statute, at least the federal anti-kickback statute. It may violate your state laws. In addition, there is some concern that if you're doing a deal with a referral source who sends you referrals for private pay as well as federal program business, and you're offering kickbacks for the private pay business, the government has said, well, that kickback for the private pay business also induces referrals for federal business, federal program business, and therefore you could still be liable for the anti-kickback statute. So there is a risk with those kind of carve-out type of situations. All right, now the anti-kickback statute, unlike the False Claims Act, is a criminal statute. A violation of the anti-kickback statute is a felony. Hey, folks, you go to jail for this one, up to 10 years in prison, $100,000 criminal fine. In addition, you can get hit up with a $104,000 civil penalty per violation. In addition, you can get hit up with trouble damages, and it can be automatic exclusion from Medicare or Medicaid. In addition, in the wake of the Affordable Care Act, a violation of the anti-kickback statute is an automatic violation of the False Claims Act, which means that you can also be hit up for, in addition to these criminal penalties, all of those civil penalties under the False Claims Act, including you have an obligation to report and repay referrals that you've made in violation of the anti-kickback statute. So, harkening back to my grade school days when we did Venn diagrams, if you want to know whether or not you got a violation of the anti-kickback statute, there has to be remuneration to a provider of referrals with the intent to induce referrals for items or services payable by federal health care programs. If you're offering that remuneration, you have that improper intent, then it's an anti-kickback statute violation unless you have structured the deal to fit within one of the regulatory safe harbors, or you've gone to the OIG and have obtained a favorable advisory opinion. If you structure the deal to fit within a regulatory safe harbor, then as its name implies, you're safe. The anti-kickback statute has a whole bunch of safe harbors, including those applicable to bona fide employment relationships, independent contractor relationships, leases, so forth and so on. Couple of points here. in order to get the benefit of the safe harbor, you have to comply with all of the terms of the safe harbor, and that can be difficult to do sometimes. Now, complying with most of them is better than complying with none of them, but it doesn't necessarily offer you the protection. Instead, if you don't comply with all of them, the test will be whether or not you had that one purpose of the transaction was to generate improper referrals, or whether or not the transaction posed a risk of fraud and abuse to federal health care programs. Effective on the 21st, effective 2 days ago, the government modified the anti-kickback statute. So with some of these safe harbors, the government has tweaked some of the requirements. Like, for example, with the bona fide employment safe harbor, they've made it easier to fit within that. For example, they took away the requirement that the aggregate compensation had to be set in advance. Now it's sufficient if just the compensation formula is set in advance. You don't have to have the aggregate compensation set in advance. The key here is if you've got a transaction involving referrals from for federal programs, you're going to want to make sure that you look at an applicable safe harbor to see whether or not you can fit within the requirements of that safe harbor. Under those new rules, the government actually issued a couple of new safe harbors. Primarily, a number of safe harbors deal with value-based care arrangements or coordinated care arrangements. The government wants to move towards these, pay for performance, the quality of care, ACO type arrangements, and these anti-kickback amendments were designed primarily to allow those types of relationships. So if you want to engage in those types of value-based types of contracts, you've now got new safe harbors under the anti-kickback statute that will allow you to do so. They also added a new safe harbor dealing with cybersecurity technology and related services that would allow you to offer that to referral sources and provide some subsidies for that type of stuff, just so long as you fit within the anti-kickback safe harbors. Now, if you can't fit within the safe harbor, you can go to the Office of Inspector General and request an advisory opinion, and they will tell you whether or not they would come after you if you engage in this particular transaction. Now, those advisory opinions are all online. The advisory opinions are only binding on the government and the party to that transaction, but they post all of those advisory opinions online. If you want to do a deal, one option is to go in there and look and see whether or not you can find a deal that's similar where the government has issued a favorable advisory opinion. That doesn't protect you, but it does give you some guidance and maybe some help in considering whether or not this poses a significant risk for anti-kickback violations. All right, the next one I want to mention is a relatively new one, and it is the Eliminated Kickback and Recovery Act. This came out in the wake of the opioid epidemic, and the government was concerned about kickbacks being offered by laboratories, recovery homes, or clinical treatment facilities. And so this statute says that you cannot solicit, receive, pay, or offer any remuneration in return for referring a patient or laboratory to a laboratory, recovery homes, or clinical treatment facilities unless the arrangement fits within a statutory or regulatory safe harbor. So it's kind of like the anti-kickback statute, well, similar to the anti-kickback statute, with a couple of exceptions. One is, note that the anti-kickback statute applies to referrals to any types of providers of items or services payable by government healthcare programs. ECRA only applies to referrals to laboratories, recovery homes, or clinical treatment facilities. On the other hand, the anti-kickback statute only applies to referrals for items or services payable by federal healthcare programs. ECRA applies to referrals for items or services payable by any healthcare program, whether that's public or private. So this one applies to private payer relationships as well. Like the anti-kickback statute, ECRA is a criminal statute. Again, you can go to jail. You can also pay a $200,000 criminal fine. Most of you are not operating recovery homes or clinical treatment facilities that are for rehab for opioid or other situations, but a lot of you, if not most of you, are operating labs. And remember, the ECRA extends to labs, even if those labs are maintained outside of the realm of opioid treatment. So if you're operating a lab, you need to be really concerned about ECRA. especially in these days of COVID, where we're doing so many tests for COVID. Labs that are engaged in COVID testing need to make sure that they're aware of ECRA and that they've structured any of their relationships with referring entities to comply with ECRA requirements. Like the anti-kickback statute, ECRA does have a limited number of safe harbors that if you fit within those, then you're safe. Unlike the anti-kickback statute, we don't have regulations implementing ECRA, so we don't have additional regulatory safe harbors. All we have are the ones that are in the statute so far. All right, the next statute we need to discuss is the Ethics and Patient Referrals Act, or more commonly known as STARK, after Representative Pete Stark, who originally sponsored the bill. STARK states that if a physician or a family member of the physician has a financial relationship with another entity, that physician may not refer patients to that other entity for certain designated health services that are payable by Medicare or Medicaid. And if that physician does make an improper referral and those services are provided, that entity cannot bill Medicare or Medicaid for those designated health services unless the arrangement is structured to fit within a regulatory safe harbor. So a couple of points here. STARK does not prohibit financial relationships with other entities. STARK just says, hey, if you've got a financial relationship physician, you can't make referrals over to that entity with which you have a financial relationship unless you've structured the arrangement to fit within a regulatory safe harbor. If you do, then that can be an a STARK law violation, and you can get hit up with penalties. Now, unlike the anti-kickback statute, STARK is a civil penalty. But the penalties include that you can't be paid for the services that were referred improperly. In addition, if you did provide those services per an improper referral, you've got to make a repayment back to the government within 60 days. If you fail to do that, you can get hit up with a penalty of $25,000 per claim. If you're a physician and are engaged in a circumvention scheme, you can get hit up with penalties of $172,000. If you've got a STARK law violation, there's a good chance you've also got a false claim. Well, you do have a False Claims Act violation, because if you submitted those claims to the government in violation of STARK, you've made a false claim to the government, and therefore the government could come after you for a False Claims Act violation. You would also likely have an anti-kickback statute violation, which would mean that you could also be subject to those criminal penalties. So again, you need to make sure that you understand STARK. Now, note that STARK applies to any financial arrangement between the physician or a physician's family member and this provider of designated health services. So, for example, if you're a hospital and you employ a physician's spouse or child, well, STARK applies to that financial relationship with that spouse or child, as well as any relationship with the physician. So you need to make sure that you look at your financial relationships with physicians and also physicians' family members and ensure that those are structured to comply with STARK. Now, note also that STARK applies to any form of remuneration, and that is incredibly broad. It's not just money. It could be offering free or discounted items or services. It could be offering above or below fair market value for services that are provided. It could be an ownership arrangement. It could be an investment arrangement. It could be a compensation arrangement. Any form of remuneration between a provider of designated health services and a physician or their family member potentially triggers STARK. Now, note that unlike the anti-kickback statute, it applies to anybody who gives or receives kickbacks or remuneration. STARK only applies to referrals by physicians to entities with which the physician or the family member has a financial relationship. The most recent amendments under STARK that just took place, became effective a couple of days ago, they modified somewhat the definition of physician, but the gist of it is still the same. STARK only applies to referrals by MDs, DOs, oral surgeons, dentists, podiatrists, optometrists, or chiropractors. It doesn't apply to advanced practice professionals. It doesn't apply to non-physicians. You don't have to worry about STARK for those. You might have to worry still about the anti-kickback statute or the civil monetary penalties law that we'll talk about in a little bit. But if you're not a physician, then you generally don't have to worry about or getting referrals from physicians with whom you've got a financial relationship. You generally don't have to worry about STARK. As I mentioned, STARK also applies if there's a financial relationship with a member of the physician's family, which includes spouse, parent, and so forth as set forth there. Now, the anti-kickback statute applies to referrals for items or services payable by any federal health care program, any items or services paid by federal health care program. In contrast, STARK only applies to referrals for certain designated health services payable by federal health care programs, payable by Medicare or Medicaid. Not any items or services, but STARK only applies to the referrals by the physician for these designated health services. Those include those that are identified there on the screen. In the new STARK amendments that took effect a couple of days ago, they did modify the definition of designated health services relevant to inpatient and outpatient hospital services. Under the new definition, inpatient and outpatient hospital services, inpatient services provided at the hospital are not designated health services, and therefore STARK would not prohibit referrals for those inpatient services if the furnishings of the services does not increase the hospital's reimbursement under the prospective payment system. So this is an important change that may help minimize, for example, a hospital's liability for potential STARK violations. So if you want to know whether or not you've got a STARK violation, you have to ask, okay, do we have a financial arrangement with a physician or a member of the physician's family? If so, is that physician making referrals for designated health services payable by Medicare or Medicaid? Well, if so, then you have a STARK law or a potential STARK law violation unless you've structured the arrangement to fit within one of the regulatory safe harbors, or you've gone to CMS and obtained a favorable advisory opinion. STARK has a whole bunch of safe harbors, more so than the anti-kickback statute, because the anti-kickback statute is an intent-based statute, so it gives you a little bit of wiggle room. STARK is what we call the strict liability statute. You either comply or don't comply, and your intent doesn't make a difference. So because of that, STARK has a lot more safe harbors. Some of those are applicable to both ownership and compensation arrangements. For example, the physician services or in-office ancillary services that allow referrals within a physician's group practice if they satisfy certain requirements. Others apply just to ownership arrangements. The most important of those are physicians can make referrals to entities they own if they are a rural provider located in a rural area, or there's the whole hospital exception that if a physician has an ownership interest in the whole hospital and that it's existed before a certain period of time, then the physician can make referrals to that entity. In order to get the benefits of these safe harbors, again, you've got to satisfy all of the requirements of the safe harbor, and those are often technical. Unlike the anti-kickback statute, where you may have a little bit of a gray area, if you miss out, if you don't comply with one of these requirements under the safe harbor, and you otherwise are making the referrals, then STARK applies and you likely have a violation. In addition to the ownership safe harbors, there are a whole bunch of safe harbors dealing with compensation arrangements. So these are the arrangements that you're going to have with most of your referring providers. For that, you need to make sure that when you identify a financial relationship, which again can be any form of remuneration, any freebie, any contract, you need to make sure that it's called up and it complies with one of those safe harbors. Now, in the new STARK regulations that just took effect, they did add some additional safe harbors, including, once like the anti-kickback statute, they added new safe harbors that deal with value-based compensation arrangements that would allow you to engage in these accountable care organizations, value-based care arrangements. So you now have new flexibility to enter into arrangements with referring physicians as long as you can structure those to fit within these regulatory safe harbors. There's a new safe harbor, which is kind of like the de minimis safe harbor. It says now that if you have a remunerative relationship with a physician that's less than $5,000 per calendar year for services rendered, then you've got a safe harbor under STARK, so long as the amount at issue is less than the amount that you paid the physician is less than $5,000 per calendar year. The compensation is not based on the volume or value of referrals. It does not exceed fair market value. The arrangement is commercially reasonable, even if there were no referrals. And if it's an arrangement for leases, that you satisfy certain other conditions. So this is an important new safe harbor that may apply to a lot of the situations where, you know, you messed up. Maybe you didn't have the written contract you would otherwise be required to have. Maybe you didn't, you made a payment that you didn't really think of it as triggering the compensation safe harbors. Under the old rules, it could have violated Stark. This is an important new safe harbor that will allow you to avoid Stark liability for kind of those smaller arrangements with physicians. There's a new safe harbor for cybersecurity technology and services, similar to the new anti-kickback safe harbor. There's a new safe harbor, or actually they modified the existing safe harbor for isolated transactions to specifically include settlement agreements with a referring practitioner, so long as you satisfy certain criteria. In addition to those new safe harbors, there were some significant changes in the new Stark regulations dealing with other terms. For example, they have clarified or modified the definitions of fair market value and commercially reasonable, set in advance, and volume or value of referrals to make it easier and more clear when those apply. So you should go back and make sure you're familiar with those definitions. They eliminated the period of noncompliance under the old regulations, which was the period of time that you could not bill for those services. The period of noncompliance still exists, but they've loosened up the way that you can cure that noncompliance by specifically adding a provision that allows you to correct inadvertent overpayments or underpayments, so long as you correct that overpayment or underpayment within the term of the arrangement or 90 days after the termination of the arrangement. So let's say you've got a situation with a physician group, or you're a hospital, you've been paying that physician group a certain amount of money, only to find out that, oh, well, we overpaid them under the contract. Under this new regulation, under this new provision, it allows you to go back and correct the noncompliance by recouping that overpayment from that physician. And as long as you correct that, recoup that money within 90 days after termination of the arrangement, then you get kind of a pass. It's kind of a no harm, no foul type situation. If you, on the other hand, you don't recoup that money, then the failure to recoup that money could constitute additional remuneration to that physician group. And unless it's structured to, or fits within one of the other safe harbors, then you probably have a situation where you could violate Stark in the anti-kickback statute. All right, there is another provision that allows you to have a 90-day grace period to obtain necessary signatures if some of the safe harbors require you to have a signed written agreement. So this gives you an extra 90 days in order to obtain that signatures for those agreements. They modified the rules for indirect compensation arrangements. They mandated, there's a new provision in there that's interesting that I haven't seen a lot of people talk about, but it's a significant issue. Under Stark, it actually allows you, when you contract with another physician, as an employer and independent contractor, to require that physician to direct their referrals to you, for example, so long as certain conditions are met, including that you can't require the referrals if the patient needs to go someplace else for the services or things like that. Well, that's been in place for a long time, but under these Stark law changes, in order to be able to direct those referrals, you have to make sure that the compensation arrangement is set prospectively, not retroactively. Under the old employment agreement, safe harbor, you didn't have to set the compensation prospectively, so you could change the compensation and modify it at any time. But if you are going to have that employment relationship and also require the physician to direct referrals to you as the employer, then you've got to make sure that that compensation arrangement is structured prospectively and can't go back and change it retroactively. There are some other requirements that are along with that too, that it's probably worth your time and effort if you employer contract with physicians to go there and look at those requirements if you have provisions in your contract that require the physician to direct referrals to you. All right. Under the Stark, the government has a website, CMS has a website that addresses Stark compliance issues, including like the OIGs for anti-kickback statute. CMS has on its website a list of advisory opinions that can give you guidance concerning Stark compliance. There's a bunch of FAQs. There's additional resources to help you with your start compliance. All right, let's move on to the next law we need to address, and that's the Civil Monetary Penalties Law. The Civil Monetary Penalties Law actually incorporates a bunch of different stuff, okay? Things like it prohibits certain kinds of misconduct, like submitting false or fraudulent claims, violating the Anti-kickback statute, violating EMTALA, failing to report and repay overpayments, failing to grant timely access if the government shows up and wants to do a survey or to check you out, failing to report adverse action against providers under the NPDB, the National Practitioners Data Bank, things like that. In addition, the ones that I want to talk about today is the Civil Monetary Penalties Law prohibits offering inducements to program beneficiaries. It prohibits offering inducements to physicians to limit services, and it prohibits you from submitting claims for services that were ordered by or contracted with an excluded entity. Let's talk about each of those. The first is the Civil Monetary Penalties Law prohibits offering remuneration to a Medicare or Medicaid beneficiary if you know or should know that it is likely to influence such beneficiary to order or receive services from a particular provider or supplier. It's kind of like the anti-kickback statute. They don't want you going out to the Medicare and Medicaid beneficiaries and offering them a bunch of inducements in order to get them to come to you for the Medicare and Medicaid services. Now, you may think, well, that's not the American way, right? Retailers offer those kinds of perks to people all the time, right? Well, that may be the case, but you can't do it in the case of healthcare. They don't want you to offer those perks, those freebies to Medicare beneficiaries if you know that it's likely to influence the beneficiary to order or receive services, unless you fit within an exception. We'll talk about that in just a minute. What's the penalty? Well, it's a $20,000 fine per violation. In addition, you could be excluded from participating in Medicare and Medicaid, and as we're going to talk about in a minute, that's kind of your death knell for working in most healthcare industries. If you violate the Civil Monetary Penalties Law, then you'll likely also have a violation of the Anti-kickback statute. Remember, the Anti-kickback statute applies to referrals to anybody, or offering freebies to anybody in order to induce referrals. That could include offering inducements to patients in order to refer themselves to come over to get services. So in addition to a violation of the Civil Monetary Penalties Law, you could be in trouble under the Anti-kickback statute, which, of course, again, is a criminal statute and could subject you to automatic penalties under or automatic violations under the False Claims Act. Well, note that inducement to program beneficiaries only applies to remuneration, if you're offering remuneration in order to induce referrals. What's remuneration? Well, remuneration is anything of value, so it's very broad, again, including but not limited to items or services for free or less than fair market value unless you satisfy certain conditions, and it includes waiving co-pays or deductibles unless you satisfy certain conditions. So if you're in a situation you want to do insurance-only billing to Medicare and Medicaid, and guess what? You probably got a violation of the Civil Monetary Penalties Law unless you satisfy some requirements. The definitions under Civil Monetary Penalties Law specifically state that remuneration does not include the following. See, these are kind of like safe harbors, right? As long as you fit within these, then you're not offering remuneration, and therefore you haven't got a violation of the Civil Monetary Penalties Law. Remuneration does not include waivers or co-pays, waivers of co-pays based on financial need or after failed collections efforts if certain conditions are met. We'll talk about that later. Certain items or services if there is a demonstrated showing of financial need, and again, certain items are met. Certain other incentives to promote delivery or preventative care, and so forth. So if you fit within these exceptions to the definition of remuneration, then you're okay from the Civil Monetary Penalties Law situation. May not protect you from an anti-kickback violation, though. All right, the next portion of the Civil Monetary Penalties Law I wanted to discuss were inducements to physicians in order to limit or reduce medically necessary services. It helps to kind of understand the background here. The government, when they switched to the PPPS or the PPS system, where you're paid based on the DRGs, so you're not based on fee-for-service, you're based on, you get X dollars for whatever this patient's whole episode of care is. Well, the government was concerned when they transitioned to that created an incentive for hospitals to provide care more efficiently, and they were concerned that the hospitals would go to the physicians and say, hey, physicians, if you help us reduce the services that we provide, we'll share some of these cost savings with you. And they were concerned by doing that physicians would start cutting out necessary care that patients need. Therefore, they came up with this particular provision, which says that the hospital or critical access hospital cannot knowingly make a payment directly or indirectly to a physician as an inducement to reduce or limit medically necessary services. That's actually a change. It used to say just services. Now it's confirmed that it's only medically necessary services provided to Medicare and Medicaid beneficiaries who are under the direct care of the patient. What's the penalty? Well, up to $5,000 per violation, plus you could be excluded from Medicare or Medicaid. It could also give rise to a potential Stark issue because now you've got a financial relationship with that particular physician that could trigger Stark. It could also violate the anti-kickback statute because you're giving remuneration to that particular physician. If that's done in order to induce referrals from that physician, it could violate the anti-kickback statute. The next one I wanted to mention is the exclusion statute. The civil monetary penalties law says that an excluded person, somebody who's been excluded from participating in Medicare or Medicaid because they did wrong stuff, that excluded person cannot order or prescribe items or services payable by federal health care programs. In addition, that excluded, you cannot, if you're the provider of services, you cannot submit a claim for an item or service, a service that was ordered or furnished by an excluded person. So if you're the physician who is excluded, you can't order prescribed services from Medicare or Medicaid. If you are an employer, you can't submit a claim to Medicare or Medicaid for items or services that were provided by an excluded individual. If you are an excluded individual and you're an owner of an entity, you cannot retain your ownership interest in that entity if that entity is going to participate in Medicare. And the big one here is if you're an entity, you can't even hire or contract with an excluded entity to provide items or services payable by federal health care programs, or more particularly, if any of the money from Medicare or Medicaid is going to find its way into that excluded individual's pocket, your employee's pocket, well, guess what? That's a violation of the civil monetary penalties law. They can come back against you for penalties of up to $20,000 per item or service that was ordered over that time period, treble damages, repayments of amounts that were improperly paid to you as an employer, even though you've got an excluded provider as an employee, and you can be excluded from Medicare and Medicaid. So you could also get excluded if you're contracting or hiring or using these excluded individuals. So pretty draconian penalties that are imposed, and so you need to make sure that you're not hiring or contracting with excluded individuals. Well, how do you do that? Well, one way is you get word from the government or you get a denial of the claim back because this person was excluded, then you know and you better change your contract. Another way is the government posts that list of excluded individuals on their website, and you need to check that on a periodic basis. You go to the list of excluded individuals and entities on the OIG's website, and it will list those persons who are excluded. And you can cross-reference that against your contractors, your employees, and those persons. You are deemed, if you go back, you can't submit those claims if you knew or should have known that that person was excluded. Well, if that person's name appears on that list, then you're deemed to have constructive knowledge, and so you may not be able to submit the claims. Now, they'll probably give you a little bit of time to catch that. I get asked all the time, how often do you need to look at the list of excluded entities? Well, the only safe thing to do, completely safe thing to do, is to look at it on a monthly basis so that you're updated with the new list. As a practical matter, you might have a little bit more time than that, but you better have a regular practice. Certainly, you need to vet all your new hires, all your new contracts through the LEIE, and periodically you need to compare your employees and contractors against the LEIE after that. Now, those are the main statutes that we deal with. In addition to those, however, there are a bunch of other criminal statutes that can be applied in the healthcare context. In fact, these are specific healthcare fraud statutes under that federal government has enacted, including healthcare fraud, false statements relating to the provision of healthcare, mail and wire fraud in submitting claims using the mail system or wire systems, theft or embezzlement in connection with healthcare, and so forth. Now, the important things about these statutes are these statutes apply to private payers as well as public payers. So most of those statutes that we've talked about up till now apply to, with the exception of ECRA, most of those apply only to claims that are submitted for items or services that are payable by federal health care programs like Medicare and Medicaid. These other statutes that we're talking about here apply to any programs, any payers. So it's healthcare fraud to Blue Cross or Blue Shield or any private payers. They might be able to come after you under these statutes, and these are federal criminal cases. So if you're dealing with private payers, you probably don't have to worry too much about Stark and the anti-kickback statute if you're purely private pay, but you still have to be concerned about those federal health care statutes and ECRA. In addition, you have to be worried about your state statutes, because a lot of state statutes, for example, I reside here in Idaho, and Idaho's anti-kickback statute, it mirrors the federal one, only it applies to private payer situations as well as public payers. So you need to be aware of that and how it applies in your state. In addition, with the private payers, you got to be concerned about engaging in fraud and abuse with them, because you may be subject to breach of contract. Certainly, if you violate the conditions of your payer contract, they can come after you for breach of contract. They could also, and there's kind of an increasing number of cases where private payers are now going after providers for fraud and abuse type issues, asserting claims like fraud, misrepresentation, unjust enrichment, restitution, interference with contracts, or other situations. Part of the written materials is an article I wrote for a national conference a little while ago talking about the application of these fraud and abuse laws in private payer situations. So don't think that just because you're dealing with private payers, not the feds, that you don't have to be concerned about this stuff. All right, let's talk about applying these laws to some common situations. First, let's talk about applying these situations with patients. Bottom line here is anytime you're offering freebies, any remuneration, free or discounted items or services to patients, you got to be concerned about the fraud and abuse laws, especially if you're dealing with Medicare or Medicaid patients, because if you're dealing with federal program beneficiaries, hey, that's going to implicate the anti-kickback statute and the civil monetary penalties law, in addition to perhaps state law claims. General rule is when it comes to private or to government beneficiaries, you may offer free or discounted services if the remuneration is not likely to influence the beneficiary to order or receive items or services payable by federal health care programs. By definition, then, you're going to fall outside the civil monetary penalties law and likely the anti-kickback statute. In addition, under the civil monetary penalties law, the Office of Inspector General has given us a de minimis guidance. Although it doesn't appear in regulation, they said, look, you can offer beneficiaries an item or services of low value, which they define as each item or service is less than $15 per item, and the total value of these items or services that you give to the patient is no more than $75 per patient per year. So you got this kind of de minimis thing under this de minimis safe harbor under the civil monetary penalties law. They haven't expressly extended that to the anti-kickback statute. Theoretically, I suppose they could still get you under the anti-kickback statute. But as a practical matter, since it's the OIG enforcing both, you're probably okay as long as you fit within that $15/$75 limit. In addition, they said you may offer free or discounted services to government beneficiaries if there's a demonstrated showing of financial need. That means a good faith determination that the beneficiary has financial need, or you've made reasonable collection efforts and have failed at those collections. In addition, in order to get the benefit here, you can't offer that financial need as part of any advertisement or solicitation. It can't be tied to the provision of other federal program business, so you're only offering these financial need discounts if you're also going to get these other federal program businesses. And there has to be a reasonable connection between the item or services that are offered in the medical care of that particular beneficiary. The key here is that, if the patient can't pay, okay, you can let them off the hook if they've got demonstrated financial need or you've made good faith efforts to collect, but they can't collect. I got a call from somebody a while ago who said something to the effect like, we want to go ahead and give these freebies to these patients. And I said, well, you got the civil monetary penalties law. They said, well, we'll just kind of we really won't collect. We'll charge them, but we won't do anything to collect. And I said, no, that's not good enough. You can't do a wink, wink, nod, nod type of thing. You have to make a good faith determination that the beneficiary has the financial need and make good faith reasonable collection efforts. You can also offer these free or discounted items or services if you fit within an applicable safe harbor. There are certain exceptions under the definitions of remuneration for you can offer certain services if they promote delivery of preventative care or promote access to items or services payable by Medicare and Medicaid and does not otherwise constitute a risk of fraud and abuse. The bottom line is you need to, if you're going to rely on those, you need to look at the specific requirements and make sure you can fit within those definitions. Among other things, if you go to my website, I also did an article on this about applying those safe harbors under the civil monetary penalties law. All right, so that's kind of the general rules with providing freebies or discounted items to Medicare and Medicaid program beneficiaries. But what about offering free tests or screens? Can you do that? Well, is that something of value? Yeah, you're giving remuneration, so that potentially implicates the civil monetary penalties law and the anti-kickback statute. Although we don't have a regulation on this, the OIG did issue an advisory opinion in which they said, yeah, you can go ahead, at least under the circumstances there, you could go ahead and offer free screening services like free blood pressure checks where you don't condition that freebie, that free service, on the use of any items or services from any particular provider. The patient's not directed to any particular provider. The patient's not offered any special discounts on follow-up services. And if the test shows that there's abnormal results, that the visitor is advised to see his or her own healthcare professional. The bottom line here is they don't want to see you, or if you're doing this, they may raise red flags. Seeing this as a situation where you're offering this like free diabetes screening or things like that, and the patient comes in and you say, oh, okay, you got this? Here, come over. We're going to enroll you now in our program. We're going to take you right over to our clinic so that you can get these additional services. That is dangerous if you're using this as a means to direct referrals over to you. Not so much risk if you offer this to the public as a whole. It's truly a public benefit, and you're not just using it as a vehicle to refer patients over to you. So if you want to engage in these free tests or screenings, then you may want to make sure that you look at that advisory opinion and you structure your program consistent with that. Now, some of these free tests or screening may fit within other exceptions under the civil monetary penalties law. So, for example, those exceptions for preventative services or services that promote care and pose a low risk of fraud and abuse. But just be careful about these free screening programs where you're just doing it in order to generate referrals for yourself. What about free transportation programs? You want to send out your bus to go out and round up the people and bring them in so that you can provide services? Well, are you providing free items or services that are of value? Yeah, you are. So you're offering remuneration that implicates potentially the civil monetary penalties law and the anti-kickback statute. Well, another option might be if that free service is less than $15 per visit and you don't offer more than $75 in the aggregate for that patient per year, then you might fit within the $15/$75 limit. Otherwise, the anti-kickback statute actually has specific safe harbors that apply to transportation programs. You would just want to check the regulations against your program or structure your program to fit within those safe harbors for free transportation. But what about waiving copays or deductibles? Can you do that? Can you engage in insurance-only billing? The bottom line here is generally no. That's very dangerous. The government specifically said, as I mentioned earlier, when defining remuneration under the civil monetary penalties law, that it applies to waiving copays or deductibles, unless you satisfy certain criteria. In the regulations, they said that you can waive copays or deductibles if there's a good faith determination that the beneficiary is in financial need or you're unable to collect after reasonable collection efforts. It's not offered as part of any advertisement or solicitation, so you're not out there doing like advertising like glass repair places, come to us and we'll waive your copay or deductible. You can't do that. And you can't offer it on a routine basis, that it has to be based on individual determination of financial need. In addition, the government has said in evaluating this, you should document factors relevant to the patient's financial needs, such as the local cost of living, the patient's income, assets. You may want to periodically review this to make sure that this person is really entitled to that financial need. The key here is, look, the government put those copays and deductibles in there for a reason, right? If there were no copays or deductibles, the patient has no disincentive to get the services. That results in increased costs. The patient may be getting services that they really don't need. So the government wants to make sure that the patient has some skin in the game. That's the copays or deductibles. And if you're out there just simply waiving that, you're giving remuneration to the patient, and the government isn't going to be very happy with you, and they could come after you for violations of the anti-kickback statute or civil monetary penalties law. If you're a hospital, there's also an anti-kickback safe harbor that allows you to waive discounts if you satisfy certain criteria for inpatient hospital stays. But what about private payer situations? We know that the government doesn't allow you to do this unless you fit within safe harbors. What about private payers? What does the private payer care about this, right? This is money that was coming to you anyway. What are they out? Why do they care about it? Well, they care about it for the same reasons that the government does, right? If the patient doesn't have to pay a copay or deductible, then there's nothing to stop them from going to getting whatever services they might want, whether or not it's medically necessary or not. And therefore, that's why your insurers require you to collect copays or deductibles. And as part of your contract with those payers, you're required to do that. If you're refusing to do it, or if you're not doing it, then you're at the very least violating your contract. You may be engaging in insurance fraud and could subject yourself to criminal penalties and other penalties, as well as civil damages from those insurance. So you better be careful about waiving copays or deductibles. Check your state laws because they may have specific rules concerning those things. Well, what about if you're not waiving copays or deductibles? You're just going to write off the entire bill. Can you do that? Well, there's not as much risk because if Medicare or Medicaid's not getting billed or the payers not getting billed, they're happy, right? They don't have to bill. Who do they care? Well, it can create a problem if you're writing off that bill in order to induce referrals for other items or services. So it's kind of a loss leader. We're not going to charge you for this service so that you'll come back to us and get us for that service. Well, then if that's the case, then it could be an inducement. So you're going to want to document legitimate purposes for writing off that bill. Maybe the patient's unable to pay, so it's financial need. Maybe it's you're unable to properly bill for that service. Maybe it is medically unnecessary, or you didn't comply with the standard of care, or there's another reason why you're writing off that bill in settlement of a claim. It could be it's part of a resolution of a legitimate dispute or a claim. The key there is to make sure that you document that you have a legitimate reason for doing that and that you're not doing it to induce other services. The OIG suggests that hospitals and presumably others should have appropriate financial guidelines for establishing financial need that's based on objective criteria and that documents real financial need. They suggest that you should recheck the patient's eligibility at reasonable intervals to ensure that they still have ongoing financial need if they're a long-term patient, and that you should document that determination of financial need in case you're ever challenged. All right, let's talk about professional courtesies. What about those situations where the patient shows up and you're just going to not charge them as a professional courtesy? Well, again, if not charging as a professional courtesy means you're going to do insurance-only billing, you're doing waiving copays or deductibles, you've got all those problems we just talked about. What about if you're going to give them some kind of a discount or something like that? Well, again, if that's a government beneficiary, then you're giving them something of value. So you're going to need to make sure that that professional courtesy policy fits within one of the exceptions under the civil monetary penalties law. Maybe it's not worth more than $15/$75, so you can fit within that. Probably not the case. If it's maybe you only offer it to non-Medicare beneficiaries, Medicare, Medicaid beneficiaries, so therefore you don't have to worry about the anti-kickback statute. That's a little bit iffy, but probably okay. What about if you're offering this professional courtesy to referring providers? Well, that can be problematic if you're doing that in order to induce referrals from that other provider. If the one purpose of that is to generate improper referrals, then you've got anti-kickback concerns. And there is no anti-kickback safe harbor. If you're offering that to another physician or a family member of the physician, there actually is a safe harbor for professional courtesies to physicians or the physician's family member, but you have to satisfy certain criteria. Among other things, you have to have a formal medical staff, so it's only available to entities that have a formal medical staff. You've got to have a written policy approved in advance. So you can't just do this on the fly. You can't do it until you've got a written policy. It has to be offered to all physicians in the service area, regardless of referrals. It cannot be offered to government beneficiaries unless there's a showing of financial need, because we don't want a problem with the anti-kickback statute or civil monetary penalties law. What about free or discounted items to your own employees? Can you offer that? Well, depends. If you're going to offer, if your plan is simply to waive copays or deductibles, hey, you've still got the same problems, right? Whether they're your employee or not. If your requirements, if they're a federal program beneficiary, you still got problems under civil monetary penalties law for waiving copays or deductibles. If they're a private payer and insurance is picking up part of these costs and your insurance contract requires you to collect copays or deductibles, you can't unilaterally just decide not to do that without risking violating your contract or fraud statutes. In addition to that, you have to be aware of if you're offering these freebies or discounted items to your employees, that may trigger tax consequences, because generally that would be considered an employee benefit. Employee benefits are generally taxable unless you structured those appropriately as part of your HSA consistent with ERISA and the like. So make sure that you go back and you look at your employee discount or employee perks, that those are structured appropriately. Otherwise, if you're not charging your employees, that may be a taxable benefit to the employee, and there may be tax consequences on that. What about prompt pay discounts? You want to offer a discount to the patients if they pay you. Well, if they're a government beneficiary, you're offering a discount. That's remuneration. You got to be concerned about the anti-kickback statute and the civil monetary penalties law. The government has issued an advisory opinion that said that, hey, prompt pay discounts are okay for government beneficiaries if the amount of the discount relates to the avoided collection costs. So you're going to write off 5% because it's cost you 5% if you had to collect it anyway. It has to be offered to all patients for all services without regard to the patient's reason for admission, length of stay, or DRG. So you're not just doing this to your high ticket, high profitable patients, but it's offered across the board. It's not advertised to solicit business, so you're not doing this as kind of a loss leader or to get people to come. You tell them about it after the fact. You notify the private payers of the program so they're aware, so that if you're offering this on a private pay basis, they have a chance to come in there and say, whoa, wait a minute, you can't do that under our insurance contract. And you got to make sure that the costs are not passed through to Medicare or Medicaid or other payers. Now, remember that was advanced in an advisory opinion. That advisory opinion is not binding on anybody other than the parties to that opinion. So just because you structure it doesn't mean that you're necessarily safe under this advisory opinion, but chances are you're probably going to be safe if you're consistent with that advisory opinion. Again, with private payer issues, you generally cannot discount copays and deductibles without violating your insurance contract. In addition, if you're doing this on a regular basis, it may affect your usual and customary charges. So to the extent that your contract is based on usual or customary charges, this may actually reduce your usual and customary charges and limit the amount that you can otherwise get paid from your payers. But what about self-pay discounts? A lot of people think, well, you can't do self-pay discounts per se. You've got to charge everybody the same amount. Well, that's not exactly right. In most states, providers may generally charge different patients or payers different amounts, so long as it's not discriminatory. You're not doing it in a way that's discriminatory in violation of the law for like protected classes like age or sex or race or those types of things. Generally, the amount that you charge is a matter of contract between you and a particular patient. We all know that you contract with all sorts of payers, right, at different rates. You have different insurers that'll pay you different amounts. And so you can contract. You don't have to charge all payers the same amount. But there are certain limitations. Some states do limit your ability to charge different rates. For example, they may prohibit you from charging insurers more than self-pay patients or charging self-pay patients more than insurers. In the last few years, some states have enacted those types of laws. There is old language from CMS that suggests that facilities that submit cost reports should be charging the same amount on their charge master and that they shouldn't have self-pay discounts. But that's from old language from years and years ago. I don't think that they're still enforcing that, but who knows? There's limitations for FQHCs, at least according to a 2018 MedLearn where they said that the charges must be uniform for all patients. And in some states, payer contracts may contain or allow most favored nation clauses. Those have been ruled out in most. But in those states where they're allowed, the most favored nation clause allows an insurer to come in and say, hey, you give us your best rate that you give anybody else. Well, if you're offering these self-paid discounts, that insurer may claim that they're entitled to that most favored nation rate. Now, again, those are not valid in most states, but you may need to check your own state on what they can do. In addition, if you're doing these discounts, beware of the substantially in excess rule, because Medicare says that the OIG may exclude a provider who charges Medicare substantially in excess of the provider's usual charges. So if you've got a regular practice of reducing these charges, and those charges for self-pay or whatever are less than the Medicare rate, then you may run into this Medicare substantially in excess rule. That lower rate may become the rate now that you have to bill Medicare, even though Medicare's usual rate is up here. If you're charging your regular practices to charge substantially less than that, then you're limited on the amount you can charge Medicare. It's kind of hard to break that because most of you aren't offering a sufficient volume of those discounts to implicate the substantially in excess rule. The test, at least most recently identified by the OIG on that, is whether the provider charges more than half of its non-Medicare or Medicaid patients a rate that is lower than the rate that it charges Medicare. That's not usually the case, but be careful and be aware of this situation, especially if you provide a limited number of a certain type of service. Well, it may affect your usual and customary rate for that particular type of service. What about requiring cash instead of billing payers? This has become more relevant in the last few years as you have more and more high deductible situations, or you've got a patient who wants to come in and you want to just charge them cash instead of billing payers. Well, the problem is if you're participating in Medicare or Medicaid, you're generally obligated to bill Medicare or Medicaid for the services, and you can't balance bill the patients more than what's allowed under the Medicare or Medicaid rules. You can't just simply collect this cash payment. At least that's the general rule. Your private payer contracts may have the same types of terms. Now, HITECH changed this. This is part of the HIPAA rule, actually. HIPAA said that under HIPAA, they amended it to allow individuals to come in there and say, hey, if I pay for my episode of care myself, then I have the right to prohibit you from making a disclosure of that episode of care to third-party payers, to other payers, so long as I request that and I pay for it myself. The net effect of that is that you might be able to use that in order to avoid the Medicare rules or insurance company rules to submit billing to them. This would allow you to actually do those cash payments. The Medicare guidance or the omnibus rule specifically addressed that and said that, hey, to the extent that you've got a private payer contract that would otherwise prohibit this, well, HIPAA trumps that private payer contract. In the case of Medicare, they specifically said that Medicare allows you to do this. So if the patient wants to agree to the cash payment and instructs you under this Medicare or this HIPAA rule, then you could accept the cash payment. There are consequences with doing that, however. Well, what about Medicaid? Well, you'd have to look at the state, because if the state requires you to collect that payment, doesn't just allow you, but requires you to collect that payment, then you've got to comply with that state rule. So if you're going to go down this path, make sure that there is no state law that requires you to bill the insurance company or Medicaid. If there is no such state law, then you could require this. Now, the downside of that is by doing that, you're going to have to comply with the HIPAA aspect of that. That means you're going to have to somehow segregate all of that data, that protected health information with that encounter, so that the payers can't access or get that information if they come in there and ask for information in the future. You've got to comply with the HIPAA aspects of that. So it's a possibility out there, but be careful. All right, that's kind of the main issues that we deal with when dealing with patients. What about in dealing with remuneration with referring providers? The bottom line there, anytime you're dealing with referring providers, you've got to be concerned about the anti-kickback statute. In addition, to the extent you're dealing with referring physicians, you've got to be concerned about Stark. Those are the federal ones. You've also got to be concerned about any state laws that may apply. I'm not going to take the time to go through all of this. Just remember, anytime you're dealing with physicians, you've got a financial relationship with a physician, giving any kind of remuneration back and forth with a physician, you got to make sure that you're structuring that arrangement to fit with Stark if that physician is going to make any referrals for designated health services to you. In addition to Stark, you also have to make sure you comply with the anti-kickback statute because you have to do both, and they don't always necessarily overlap. If you're not dealing with physicians and you're dealing with nurse practitioners or other technicians or other healthcare providers who are not physicians, as defined here, you don't have to worry about Stark. You still have to worry about the anti-kickback statute. So you're still going to want to try to structure that deal to fit within a regulatory safe harbor. If you can't fit within a regulatory safe harbor, you're going to want to consider advisory opinions or, quite frankly, consider the risk. Is there a significant risk of program fraud and abuse? And is that risk worth it to you realizing the potential consequences? In addition, remember that you still have state laws. State laws may not only apply to arrangements with physicians dealing with government programs, but also private payer situations. So make sure you consider the state laws. All right, let's talk about repaying overpayments. And I apologize for going over a little bit, but we've got a lot to cover here. Feel free to hop off if you need to, and you can pick up later if you want. We'll record this and make it available to you. With repaying overpayments, in the wake of the Affordable Care Act, they confirmed that if a provider has received an overpayment, the provider must return the overpayment to the federal government or the state government or their contractor, their intermediary carriers like Noridian. And in addition to doing the repayment, you've got to notify that entity of the reason for the overpayment. And you've got to do that within a certain period of time. It's either got to be at the later of 60 days after the overpayment is identified, or if you're paid on a cost report basis, the date the cost report is due. If you fail to do that, well, the knowing failure to do that report and repayment converts it into a False Claims Act violation. So you could be subject to all those penalties we talked about earlier, including $11,000 to $22,000 per claim. You can also get hit up with a civil monetary penalty under the Civil Monetary Penalties Law of $20,000 per penalty. You can get hit up with treble damages, and you can be excluded from Medicare and Medicaid. So there isn't any kind of this finders keepers rule. That's not the way the government works. If you weren't entitled to that money and you got that money and you know it, you've got an affirmative obligation to repay. If you don't, you can get hit up with all of these penalties. Well, what's an overpayment? Overpayment is funds a person receives or retains to which the person, after applicable reconciliation, is not entitled. So it could be payments for non-covered services, payments in excess of the allowable amount, errors and non-reimbursable expenses in the cost report, duplicate payments, receipt of Medicare payments when another payer is primary. The one that I deal with the most often are payments that are received in violation of applicable regulations or conditions of that payment, including violations of Stark or the anti-kickback statute or the like. When it comes to the overpayment, you only have a 6-year look-back period, so you only have to repay for the prior 6 years. It's kind of a statute of limitations on that. Well, that time period for repaying runs from the date that the overpayment's identified. In the guidance that we got out, received from this, the payment is identified when you either know or should have known that there's a problem, and you have quantified the amount that you have to repay. So it doesn't run from just when you identify a problem. It runs from the time that you quantify the amount that you're going to have to repay. Now, this doesn't allow you to sit back and just, play ignorant, right? Because it runs when either you do have actual knowledge or you should have known. If you're acting in reckless disregard or intentional ignorance, then you're deemed to have known, and that time limit is going to start ticking. To that extent, the government made clear that you've got a duty to investigate potential overpayment situations, and as part of your compliance plan, you're going to be expected to engage in regular or reasonable efforts to identify potential situations. Certainly, if you have a situation that triggers a potential problem that you should know, things like significant and unexplained increases in your Medicare revenue, review of bills shows incorrect codes, discover services were rendered by an unlicensed provider, you have an internal external audit discloses overpayments, or you've got Stark violations, well, those things you know that there's a problem, and therefore you have to act with reasonable diligence in order to resolve those situations. The government, if you don't act with reasonable diligence, the government can still come back to you as if you knew. Reasonable diligence, the government says they want to see that you have some kind of proactive monitoring as well as reactive investigations if something actually comes up. Now, that, as I mentioned, that 60-day deadline runs from either runs from the time that you either knew or should have known of the problem and you quantified the amount that you owe back. So the government has said that they expect you to exercise reasonable diligence. So once you become alert to the problem, you've got to exercise reasonable diligence in order to conclude your investigation and quantify the amount. They said that at most you would get up to 6 months, and then that 60-day period would run at the end of that 6-month period when you concluded that I owed back this amount of money. Then you'd have 2 months after that. So you could have up, theoretically, I suppose, up to 8 months, but that's assuming that you are otherwise acting with reasonable diligence. If you do that, if you engage in this overpayment, that deadline is suspended by the OIG self-disclosure protocol or the Stark self-disclosure protocol. So if you decide to enter into the OIG protocol or the Stark self-disclosure protocol, that suspends that time period for the repayment. In order to do that repayment, you may either use the Medicare contractor, so go to Noridian or your other Medicare contractor. That's usually what we recommend that you do. By doing that, you're not necessarily inviting OIG or CMS in. Alternatively, if you think it's a pretty bad situation, then you may need to go to the OIG or CMS in order to minimize your potential exposure on those situations. My general rule is, though, unless it's a pretty clear violation, do it through the repayment situation through your Noridian or the like, rather than going to the OIG, because if you invite the OIG in, who knows where they're going to stop looking. Note that the repayment or the repayment rule, so payment to Noridian and the like, doesn't necessarily resolve anti-kickback or OIG actions. So even if you report to like the Noridian, they could still report you to the OIG or CMS, and OIG and CMS can come in and do their own investigations. If you do think it's a bad case, you may want to consider your other protocols, including for violations of the anti-kickback statute, civil monetary penalties law. There's the OIG disclosure protocol that's available there at the website. For Stark cases, there's the separate Stark self-disclosure protocol. For the OIG, again, I think it has to be a pretty clear violation before I would ever invoke that. Just because of the potential ramifications, I would rather do a repayment through the payer. But there may be situations where you know that it's a serious situation and you want to get whatever benefits you can by going to the government first through the OIG protocol. When it comes to Stark, CMS, I think, has been a lot more reasonable when it comes to the self-disclosure protocols, and so I'm generally a proponent of using the Stark self-disclosure protocol when it comes to Stark violations. The government has a whole bunch of other resources dealing with compliance issues on their OIG's website. You can go there and access those. Real quickly, I just want to cover a couple of things on the Provider Relief Fund, because that's a hot topic now. You received hundreds of thousands or millions of dollars in these PRF funds. You think it's great, but remember, there are strings attached to that. The government expects to get that money back if it's not used for a proper purpose as allowed by the regulations. The government sent out all that money at the front end, and since then it has been periodically revising the rules associated with the use of that money. Most recently, the coronavirus stimulus package that came out in December modified the rules for the use of Provider Relief Fund, or specifically what you can claim in your for the use of that fund. That was came out at the end of December. Just a couple of days ago, on January 15th, the HHS published new guidance concerning the PRF fund. That's available on the government's website. Because these rules seem to be changing periodically, flipping back and forth, you really need to come up with a process so that you stay up to date on the use and the reporting of those PRF funds, either through your industry organizations, or you should periodically go into the government's website dealing with the PRF funds and look at those sections dealing with the reporting and the repaying, because those have changed, most recently as of January 15th. In short, when it comes to the use of those funds, when you accepted those funds, when you retained those funds, whether you affirmatively attested or not, you agreed to comply with the terms and conditions associated with that. If you fail to comply with those terms and conditions, guess what? That's a false claim. That could be subject to all those penalties that we've been talking about. You have to comply with the relevant terms and conditions, and in that terms and conditions, they have this language that you also have to comply with any other relevant statutes or regulations. So it's possible that the government could pass additional rules and regulations that you're going to have to require, that are going to require compliance. So you need to stay up to date on those types of things. The key for you guys now is the use of the PRF payments. Generally, you've got to use those PRF payments to prevent, prepare for, and respond to coronavirus. The payment shall reimburse the recipient only for healthcare-related expenses or lost revenues that are attributable to coronavirus. That's what the terms and conditions says. We've gotten additional guidance from HHS concerning what that means, what you can use those payments for, and what you can claim. Most recently, as part of the coronavirus stimulus package in December, they modified the definition of lost revenues. That has been updated on January 15th concerning how you can claim or what you can claim for lost revenues. So make sure you're familiar with that so that you're doing the documentation you need in order to justify your use of those PRF funds if and when you're ever going to have to account for that. The terms and conditions identify a bunch of impermissible uses, the most important of which is that you cannot use PRF payments to cover expenses or losses that have been reimbursed from another source. So if you have provider payments that are, or a payer that can pay for that service, or you've gotten funds through PPP or other state grants or other sources, you can't double dip. You got to use those other sources first, and you can't claim PRF funds if you've otherwise been reimbursed for that same fund through some other source. There are other things that you can't use the PRF funds, but it doesn't come up very often. In the most recent guidance that we've got, providers generally can claim expenses that have incurred, at least currently. That may change with the new administration, but the current rule is you've got to use all those funds by June 30th, 2021. After June 30th, 2021, you're going to have to refund any of those unused funds. So you may want to look back and consider, okay, what funds have we got left? Do we have legitimate COVID-related purposes that we can use those funds consistent with the terms and conditions? And if so, you may want to use those funds before January 30th, 2021. You need to make sure that you maintain documentation concerning your use of the funds and your eligibility and the like. So you've got to maintain those for 3 years. If the government requests it, you've got to submit copies of those records to the government, and you've got to cooperate with any audits that the government's going to do. As part of that certification process, you certify that any information you're providing to the government is accurate. If it's not, the government can come after you for criminal, civil, or administrative penalties. The government has said that they can come after you, they can recoup funds. In addition, to the extent that you got money improperly, you've been overpaid, the most recent guidance that we got before this last one was that you have an affirmative obligation to turn that back into the government. You may want to watch that and see what's going to happen with that. It's just, the government's told us that with this PRF payments, they're concerned about people out there abusing these payments. You better make sure that you've got the documentation to support it. If not, you can be liable for all sorts of False Claims Act penalties, federal fraud and abuse. You can be excluded from Medicare, Medicaid, and all that other stuff. All right. That is the end of our program today. We covered a lot of stuff. I appreciate your patience. If you have additional questions or need additional resources, you can go to our website. It's all free. We've got a lot of publications on the things that we talked about today, including a lot of the exceptions and the applications to common situations. We've got webinar recordings dealing with these types of issues. We do have our continuing compliance programs coming up. Next week is the new information blocking rule. After that, next month, we'll be talking about things like EMTALA, HIPAA, and those types of things. So stay tuned. If you have questions, feel free to email me. Otherwise, thanks very much for your participation.